Hello, I'm Ian Snow from Friends of the Court on Live1.tv. Today I'm seated with attorneys George Basayas and also real estate attorney Constantine Kapetanos. Today we're going to be talking about the role that an attorney plays for first-time home buyers and sellers. George, introduce us to Gus, please.
Yes, Constantine Kapetanos is also known as Gus. We'll call him Gus for the purposes of this show. Important to note, we're making a simplified version of how residential real estate closings go. And our lesson here is not to be specifically relied on by you. Our advice is to you to seek your own attorney if you do a closing, or if you have an attorney, we advise you to speak with that attorney. So this will be a general discussion about how real estate closings go. So Constantine, tell us about your practice. What do you mainly do?
Mainly real estate work in the residential arena. It's what I like doing best. I like working with buyers of homes, 1, 2, 3 family homes.
And what about sellers? Do you have sellers also?
I have sellers as well, buyers and sellers, both ends of the spectrum.
Okay, so let's say I'm a buyer of a home and I come to your office. I was referred by Ian. Go to this Constantine Kapetanos. He's a good real estate lawyer. So I come to your office. What do you tell me on our first meeting? I'm a buyer of a home.
Okay, the first thing I'm going to tell you is to get an engineer to look at the home. To me, that's the most important thing that you can do. It's really your only bite at the apple, because it's your one opportunity to really assess the condition of the home. You know, you're going to buy a home. You're going to go into contract. There's going to be certain standard representations that the plumbing, heating, electrical systems, appliances will be in working order. But that just means that they're going to be in working order as of the day of closing. That's no forecast as to, you know, how old this equipment is, how long it's going to last. There may be certain hidden issues with the home. There may be foundation cracks. There may be problems with maybe underground oil tanks, things like that. That is always very important for you to assess. And it gives you an opportunity. I always tell people it's the best money that they could spend. Engineers can run you anywhere between $500 and $1,000. But again, it's the best money that you can spend because it's an investment, any way you look at it.
Can you, as the lawyer, will you refer them to a particular engineer?
Generally speaking, I don't. A lot of times, brokers will make a referral. And I always tell you, you know, the best advice I can give is speak to other people that have gone through the process. You may have family members, you may have relatives that have done it. Now say, look, if you were comfortable with the engineer, use that engineer. Because again, engineers are human. You know, they may be good for somebody else, they may miss something for you. So there's always that possibility. But just to get back really quick to what I said about the engineer inspection. Your engineer can go in there, and I always tell people, don't nitpick the little things. You're buying a home, you're gonna fix it the way you like it. There's certain things you're gonna do. You wanna go in there and make sure that the home is structurally sound. That's your most important thing. Now, if something's serious, if a serious issue presents itself, that's your opportunity to go back to the seller at that point and say, look, you know, engineer told me this is gonna cost me $5,000 or $10,000 to fix, or the heating system is on its last leg. That's your opportunity to go back, and you'll either work out. I always recommend that you work out a credit, because you don't want sellers really to fix things, because there's a different mentality when you're a seller as to a buyer. A buyer's plan is, you know, long-term. Sellers is, you know, I want to patch it up and move on. So the other thing is, if an engineer turns around and tells you the house is in great shape, again, what you bought yourself is peace of mind. Okay, so on all. From every corner, I mean, an engineer is the best investment.
When you say work out a credit, are you saying you tell the seller, hey, you have to reduce the sale price of the house by this amount because I'm going to have to spend $5,000 for a new roof?
Right. Usually the brokers do that. You know, I will recommend that the client talk to the broker, because the brokers negotiate. We as attorneys negotiate the legal terms. This is more of a not technically a legal term. It's just relates to the condition of the home.
Okay.
Just like when you went in and first made your offer to the home. Now things have changed because you've gotten an engineer.
Got it. So that it's clear to the listeners, this is something that they will spend money before they even sign a contract to buy the house.
Absolutely. And like I said, it's the best money you could spend, because again, even if you spend it, and I've had it happen, not many times, but I've had it happen where an engineer said, keep away from this home. This is gonna be a big problem. And then you tell yourself, you know what? I could have bought into this is one of the biggest expenses of somebody's life. And you could have bought into a very big headache. But you know what? You've gotten out of it with your $500 or $700 that you spent for the engineer.
Okay, so that's your first meeting with a buyer. What about your first meeting with a seller?
My first meeting with a seller really is just gonna be for him to give me as much information that he or she has on the home. I'd like to see if they have a survey. I'd like to see if they have a title policy for when they purchased the home. I'd like to see a copy of a deed if it's available, so that I could see who owns the home, just to make sure that the person that's selling is in fact the owner of the home. They may have a husband or a wife or another family member on the home with them, because they all have to join in on the contract and the deed when the house eventually sells.
Now, there are some states where people don't use lawyers at all. Like I've heard in Florida, people go through the real estate broker, and the real estate broker gives the contract, everybody signs, and before you know it, you buy a house. Would you recommend somebody representing themselves in a real estate closing? If yes or no, why?
I probably wouldn't, and I'm not saying it because it's what I do for a living. I'm saying it because this is usually one of the biggest purchases that most people do. It is the biggest purchase in your life, essentially. So you want to just make sure that you are adequately protected. There are so many ins and outs of a house closing that, you know, if you miss something, it can live with you forever. And again, if you talk about what you're spending on a home, I mean, most homes these days, even, you know, forget about New York, you know, boroughs of New York or New York State as a whole, but you're spending a lot of money for this home. So you want to make sure that your interests are going to be adequately protected, and that you're going to be protected, having peace of mind that you've been represented and you've made the right decisions in connection with the purchase.
What does a lawyer charge usually for a real estate closing?
I'll tell you, it's varied. I would say on a conventional real estate transaction, just based on my own experience, I mean, they can go as, you know, I could say anywhere between, say, $1,500 and $3,000 for a 1 to 3 family home. I don't take a cookie cutter approach personally, because I don't think I'm doing my client a service if I do that. Because if I charge my client too little, you almost feel compelled to fit within that budget, and I don't want to do that. I always give people a range. I say, look, you know, if all goes well, this is what it's going to be. If there's going to be any issues along the way, I'll advise you and let you know. But the whole idea is to be informed along the way. So I don't want to shock anybody ever at a closing. So you should always know what you're going to pay up front, and if there's going to be a possibility for an increase in the fee.
Who prepares the contract?
Generally, the seller's attorney prepares the contract.
Okay, so the buyer comes, he does an engineer inspection, everything's fine. What's the next step?
The next step is to get the contract. If I'm representing a buyer, I'm going to get the contract. I'm going to review the contract from top to bottom. I can tell you that most contracts come in, generally speaking, you know, there's a standard form that most people use, and then there's a rider that kind of you know, supplements the standard form. But generally, you know, we as attorneys know what to look for in those contracts. Like I said, there's many provisions in there, and there's a lot of fine print. And you know, you definitely need the experience of somebody who's seen this before to go through it. And it's very important to understand. And if you don't understand something in a contract, ask questions. Very important that you ask questions.
So you get the contract from the seller's attorney, correct? And if you're the seller's attorney, you provide the buyer's attorney with the contract.
Exactly.
Or the purchaser's attorney with
Yes.
the contract. And at that point in time, let's say a contract is signed. What happens then?
Well, if you're representing the purchaser, at that point, that purchaser is going to take that contract, and if they're getting mortgage financing, they're going to take that to their lender, and they're going to start that mortgage process.
But isn't there usually a deposit with the contract?
Oh,
How does that
absolutely,
work?
yes,
How
yes.
does that work?
Oh, usually with the contract, the standard deposits are 10%. That's 90% of all residential contracts have a 10% down payment. And that money is written by the prospective purchaser and given to the seller's attorney, who deposits that money in escrow.
Does it earn interest, the money in escrow?
Generally, no, unless you make provisions for it. If there's a provision made for it, if we're talking about a very, very expensive purchase, and we're talking about a substantial down payment, then you would want to make provisions to have that down payment earn interest in a separate account that will be set up.
Okay, but generally speaking, for a regular 1 to 3 family house, you do not?
No, they go into what we call the attorney Iola escrow accounts, which do earn interest, but unfortunately not for the parties involved in the transaction.
Okay, so now as the buyer and as the seller, once the contract is exchanged and once the seller's attorney has received the money and placed it in his Iola account, in his escrow account, what's next for the buyer and what's next for the seller?
Well, the buyer is gonna, like I said, is gonna start his or her mortgage process. And that's a process that could take anywhere up to 45 days. We generally make provisions. If the contract is subject to a mortgage, what that means is that you'll have a period of time, up to usually 45 days is a conventional time, to procure a mortgage commitment. So what does that mean exactly? A mortgage commitment means that the bank has reviewed all of your documentation and is satisfied to lend you the amount of money you're looking for in the mortgage. Now, that commitment is not a 100% guarantee that you're going to close and that the bank's going to fund their closing. What that means is that you've met the requirements, and that commitment usually has certain conditions as well. It may say that it's subject to you maintaining your employment, wherever your employment is. So you have to make sure that you meet those conditions, because there is a line of demarcation in all of these contracts. And there's an assessment of risk. And the question is, who has the risk and when? Now, the buyer, the seller has the risk anytime up until that mortgage commitment letter is received, okay? Because that's the line of demarcation. So what does that mean? That means that the seller might have had other prospective purchasers that came in and maybe even offered more for that home after you've got into contract with this buyer. And you have to technically tell those prospective purchasers that, no, we're in contract. So what's going to happen? That buyer's going to look elsewhere to buy a home. Now, the risk then shifts to the buyer once you get that commitment letter, because once you get that commitment letter, that's when you've told the seller that, hey, I'm good, I'm ready to go. Now the question is, you have to meet those conditions. So usually what I tell people is work closely with your mortgage representatives and make sure that those conditions are not onerous. They're conditions that you can meet, okay? But again, there's certain conditions that come in that you can't meet, like losing a job.
You told us about the responsibilities of the buyer and the seller during the process of the mortgage commitment. What about you as an attorney? You have a 45-day window. What if it's day 40 and your client doesn't have a mortgage commitment yet?
Okay.
What do you do as an attorney?
At that point, what I'm going to do is I'm going to send a letter to the other side and essentially tell them that we're going to require an extension of time. Sometimes the seller's attorney would ask that you give a reason for the delay, and if once I know the reason, I'll also state the reason for the delay, and I'll say, please extend us another 2 weeks or 3 weeks. And if you don't, then demand is hereby made for the return of my down payment, meaning I haven't met that 45-day window, and I'm not gonna, I want to protect the down payment. That's the most important thing you want to do at that point.
So the bottom line is, if a buyer proceeds with good faith for a mortgage application and is unable to get the mortgage application, the mortgage commitment, there has to be a refund of the deposit money.
Yes, exactly. And the key word that you used is good faith. That's a good point, because you do have to apply in good faith. You can't go into a mortgage, looking to seek a mortgage, knowing that you have, 5 judgments against you and that you haven't paid your bills, because at that point, you don't have a good faith, you don't have a shot at getting that mortgage. So like George said, good faith. Well, I have a job, I think I'm gonna get it, I have enough money saved up in the bank, and I think I'm gonna get it. But again, anything can happen. So yes.
So when you mentioned earlier that generally speaking, people have to put down 10% as a deposit, do you also advise your buyer client what their closing costs are gonna be?
Yes, I mean, I won't know at that point because it varies from lender to lender. But for the most part, I can tell them, for example, if you're borrowing money, okay, and let's just say, for example, you're in the city of New York, okay, there's a mortgage tax you have to pay, which is at a higher rate than outside of the confines of New York City. So we know that number right off the bat. We know that if the house is going to cost more than $1 million, there's what they call a mansion tax, and a buyer has to pay 1% of that as well. And then I could just say, generally speaking, I tell people, just to be safe, anywhere between 5 and 6% of the amount that you're borrowing should be a safe number. And a lot of times people say, ooh, that sounds like a high number. But you know what? I'd rather prepare for a higher number and be satisfied that it's lower than the opposite, because the opposite can create a real problem. Because if you go to a closing and you don't have the funds necessary to close, then that can be an issue, and you can put your down payment at risk.
So if somebody's buying a $500,000 house, they need $50,000 for the down payment. They also need 5% minimum
Of what they're borrowing.
on the side.
Right, so if they're
For
borrowing
closing
80% of that amount, you're looking at roughly 400,000. Yeah, you would need about a good $12,000 to $15,000 for a transaction like that to close. And again, that's, those are not hard closing costs. Like I tell people all the time, yeah, they're called closing costs, but a lot of these things involve, escrows, because a lot of times the banks are paying your insurance and your taxes, so they take a little money up front. It may involve prepaying a period of taxes when the taxes are due. For example, if we close, for example, in December and the next tax is due in a couple of weeks, generally banks want you to prepay anything that's due within 60 days of the closing.
What can the seller expect to pay in closing costs in a typical real estate transaction, residential?
Well, he or she is gonna pay his attorney, and they're also gonna pay transfer taxes. And again, if we're talking about the boroughs of New York City, you have both a New York City transfer tax and a New York State transfer tax. So that can get costly with those two transfer taxes. And also when you're out in certain parts of Long Island, you have other taxes like the Peconic Bay transfer tax, but that one is paid by the purchaser. So there are a number of taxes that are paid and collected at closing.
Do your clients ever ask you about whether or not they would have to pay capital gains, or do you?
They do, and my answer is always the same. I defer to the advice of their accountant, because their accountant is going to know what tax bracket they're in. They're going to know how this home has been, whether it's been, what the depreciation has been, what the basis of the home has been, whether there's been a step up in certain times. When you have a husband and wife, sometimes there's a step up in basis if, say, somebody passes away. So the intricacies of that I leave to the accountants, and that doesn't get paid at closing. Capital gains is something that's done the next tax year. That's when that's accounted for. There is one tax, though, however, if you're a non-resident of New York State, they will ask you to pay an estimate of capital gains. So your accountant would have to help you with that, because that would be collected at closing. It would only be a portion of what the possible exposure can be, but that would be paid at closing if you're a non-New York State resident selling in New York State.
Right. So do you refer your buyer clients to mortgage brokers or banks?
Again, I can only speak for myself.
Yeah.
And like, you can refer somebody and maybe your good experience may not have been experienced by somebody else. So it's very difficult. I like to keep away from the referrals when it comes to what I do, because I like people, I can't vouch for anybody else. I can make a recommendation. I can say, hey, there's 3 people that people have gone to before and they've been satisfied, but I always want people to make their own assessment when it comes to that.
Do you know the difference between, between different types of mortgages, conventional mortgages, FHA, VA?
Yeah, I can give you a brief dissertation, I guess, on the differences. But most of my clients go with conventional mortgages, right? Which permit you to borrow up to 80% of the appraised value of the home. Okay.
So that's important what you just said. So we said 10% down, and then most people get a conventional mortgage where they're only giving 80%.
Correct.
So they have to come up with that other 10% also.
At closing, plus their closing costs.
Right. So not just that $50,000 down. You got to have another $50,000 in the bank plus your closing.
For sure. Well, I always tell people, very simple. You need 20% plus your closing costs.
Got it.
That's the way you look at it for conventional financing.
Okay.
And always one little point to remember, when banks lend, they lend on the percentage we just talked about, and conventional would be the 80%. It's 80% of the appraised value, not 80% of what you're paying. So for example, if you're buying that house for $1 million and you're expecting $800,000, and now the bank comes in and does their appraisal, and they appraise it at $900,000. 80% of $900,000 is different than 80% of $1 million. So
does that fall within the realm of the contingency clause?
it does.
Okay.
It does.
So then you can get out.
You can, right, or you can renegotiate the contract.
Okay.
Right. So
You,
that's an
you
opportunity.
probably would renegotiate the contract.
If that's the client's desire, yes.
So we mentioned that. What about VA loans and FHA loans? Have you had experiences with those?
I've had some experiences with them. FHA loans are generally given to lower income Americans. They're more strict in terms of their underwriting process. They're loans that are insured by the U.S. government, and they'll give you a higher percentage.
Like 95%?
Oh yeah, you can get 95.
Whereas the VA loans, you could get 100%.
Right. The difference though is that in a VA loan, you may have more expenses up front. An FHA loan, the one expense that's that's important to note is that you're subject to what they call PMI, which is private mortgage insurance. So in addition to your regular monthly payment amortized over 30 years, you're also paying a certain sum every month in addition to that payment, which essentially insures the loan. It's almost like paying a premium for a loan. And you'll be paying that.
This is with FHA?
Yes, with FHA. You'll be paying that until the home reaches 80% appraised value. So, if you're borrowing 95%, you're going to be paying that PMI.
Interesting, I didn't know that.
Yeah, you're paying that up until the time that you reach 85%.
Okay, really quick, because we're
80%.
running out of time.
Yes.
What about title? Who orders title?
Generally, it's the buyer's attorney that orders title, reviews it.
Okay.
Title insurance, very important, because you want to make sure that when you purchase that home, you're going to be the rightful owner. Nobody's going to come in and say, hey, I had a long-lost cousin or a long-lost brother that never joined in the deed and should have been there. So title insurance is very important. And what title insurance also does is there's many searches that are done in connection with the title report. So you really get a nice forensic view of the home to make sure that there's no violations, to make sure that all permits have been closed out, to make sure that the house conforms with all municipal laws, so on and so forth.
And liens, it shows you.
Oh, absolutely. It'll show you if there's any liens.
And
like
if
mortgages, for example.
If there's a lien on the property and the seller refuses to satisfy it, can the buyer cancel the deal?
Absolutely, but there's usually provisions that are made in the contract.
Okay.
When I represent sellers, I make sure I put a cap on the liability of a seller, because we don't know. There could be a lien out there that they didn't know about.
Right.
So they don't want to be responsible for something that's, excessive.
Ian, do you want to?
Well, George, we wanted to ask, what is the time of the essence letter?
Time of the essence letter, generally speaking, when you go into a contract, there's a timeline of when you have to close, from contract to closing. And the general timeline is anywhere between 60 and 90 days. We talked about the 45-day mortgage contingency, that's separate and apart, but the 60 to 90 days is the timeline. So if that time comes and goes, at some point, seller's going to say, well, where are you? When are we closing? And the way that you're going to start the process, because look, the scary part about not closing when you're supposed to be closing is that you're putting your down payment at risk, okay? And that's a substantial amount of money. It's 10% of the value of the home. It's not something automatic that's given to the seller. You still have to go through a court proceeding, but you have to go through the motions. And the first motion in enforcing the closing date is to serve a times of the essence letter. It basically says, hey, I'm setting a closing now, and you got to give a period of time. Generally speaking, I would say 3 weeks is a safe period of time. So you're going to say, I'm setting that down as a date of closing. It's what they call a law date. You don't appear closing on that date, then I'm going into court to start the process to foreclose on your down payment. Now, if a client of mine gets if we get a time of the essence letter on behalf of my client, my job would be to respond and say, you haven't afforded us enough time, and you hope to just buy some more time. You're not looking to delay the inevitable, but you do want to get yourself some time, because there are things that happen, and especially during COVID, there was a lot of delays with mortgages, and people were, just things weren't happening on time.
Right.
Where does the closing take place?
Generally speaking, the contract would say that the closing will either take place at the seller's attorney's office or the lender, and that that has to be, usually it has to be in the venue of the home. In other words, you can't really force somebody that's representing a client, representing a seller, for a home in Queens to close in upstate New York.
Is it fair to say, though, that when there's a bank involved, it's usually at the lender's office?
The lender's or the lender's attorney.
Yes.
Yes.
Okay.
Yep.
All right.
Thanks
Very
a
interesting.
lot, guys.
Okay, my pleasure.
Yeah.
I hope some of this helps. And again, like we had talked about beforehand, I always defer to the advice of your own attorney. It's always important to get your own attorney. Use this as a framework, but your attorney is going to give you the best advice.
We've been talking with Constantine Kapetanos, together with attorney George Basayas. You've been watching Law Made Easy, part of a series by Friends of the Court. Please subscribe to our channel and learn more about law. Thank you again, George.
Thank you.
Thank you, guys.
Thank you. It's my pleasure.
Gus.